Commonwealth versus Carlson.
Mr. Gallagher? Don't worry, you just get additional time if she hasn't reset the clock.
May it please the Court, Sean Gallagher for the appellant, Sandra Carlson. In this case, Ms. Carlson was convicted of motor vehicle homicide by negligent operation of a motor vehicle. That was in the East Brookfield District Court. As the appellant sees the issue in this case, the question was whether or not there was sufficient evidence, particularly on the question of causation, for the matter to go to the jury. And within the question of causation, whether or not there was an intervening, superseding cause that would free Ms. Carlson from liability in this case. A brief sketch of the facts would be these. There was an accident at an intersection, July 4th, around noontime. There were two streets in the intersection. Speed limits on each were about 25 miles an hour. They were both narrow roads. They were both windy roads. One road, Mechanic Street, was governed at the intersection with a blinking red light.
Well, the facts of the accident aren't really what controls here, are they? It's the question of whether the victim's decision to end the intubation was a superseding cause of her death.
That's what I perceive.
That's really is the issue, isn't it?
Exactly what the issue is.
Okay, and
Yeah.
Would you agree, I mean, it seems to me we're talking fundamentals here. If something is reasonably foreseeable, then that something is not a superseding cause.
I agree with that.
Okay. So it boils down to, is it reasonably foreseeable that injured victims of car crashes might decline medical treatment? And why isn't that reasonably foreseeable? We know that people have, for a whole variety of reasons, do decline medical treatment from time to time. Why isn't that reasonably foreseeable?
I would state the facts a little bit more particularly than that. In this instance, there was a declination of medical treatment, but it was a case in which her doctor told her that her injuries were absolutely survivable. Her family begged her to stay on mechanical ventilator.
What you seem to be doing, if I read your brief correctly, and I agree, you're trying to say that we're going to judge whether the victim's decision to decline treatment was reasonable. And that seems to be not the issue. It's not whether the victim was being reasonable. The issue was whether it was reasonably foreseeable. What do we do, for example, with people who, on religious grounds, are going to decline a blood transfusion? And they could clearly survive the accident if they'd agree to a blood transfusion. But on religious grounds, they will not do it. Are we going to sit here and judge whether it's reasonable? It seems to me it's just a question of, was it foreseeable? Was it reasonably foreseeable that a victim might decline medical treatment?
I believe the question would be whether or not, on the particular facts and circumstances of this case, was it reasonably foreseeable that medical treatment would be declined.
Was there any evidence of what the victim's life would have been like if the tube had not been removed? I'm just wondering.
No. But the experts in the hospital, the doctor overseeing her care, hypothesized or told her that the anticipation would be the tube would be in for anywhere from 24 to 48 hours and the outside 3 to 4 weeks.
Yeah, I read that, but I was wondering whether there was any evidence of what her life would have been like, if the tube hadn't been removed. What would her life have been after the 2 to 4 weeks or the 3 to 4 months that they did?
There was no evidence as to what would happen after that.
Well, wasn't an additional fact that the doctor had indicated that if she didn't have the tube, she would die?
That's correct.
If she didn't have the tube at that point.
At a point in time, she was told that if the tube was removed, death would be certain and imminent.
And it was removed and she died within 12 hours.
That's correct.
So your position is that it's not when, I think your position is when a patient is informed by a doctor that medical treatment, that if she refuses it, it will lead to death, that's not reasonable.
That's correct. That's part of the position.
Well, then
Well,
I'm going to
again,
come back to,
of course-
what do you do with the people who on religious grounds refuse a blood transfusion? Are we going to sit here and say it's not reasonable to be of that religious faith? The person's a Christian Scientist, wants to decline all medical treatment of all kinds. It's not reasonable.
It may be very well reasonable for that person.
But it's not reasonably
But is it reasonable
foreseeable.
to impute that to the person who's negligent?
No, the question is it reasonably foreseeable? When you look at reasonable foreseeability, do you take into account that some people, for wholly unreasonable reasons, will decline medical treatment from the vast majority of people? Or do you just simply say you have to take into account that some people will decline medical treatment? It's reasonably foreseeable that some people will decline medical treatment. And it seems to me that one of the problems you have in this case, and only one, is that the legislature has recognized and codified the fact that people, for reasons that no doctor would agree with, for example, can reasonably withhold medical treatment. Because that's one way of saying there are a whole group of people out there who, for whatever reason, are going to want to decline medical treatment, and the legislature simply said that's okay to do. Not to give it its imprimatur, but to help the arrangements, primarily between the medical staff and the patients.
One of the ways that it's defined as to whether or not an event or an action is a superseding intervening cause is whether or not it's highly extraordinary. And if a person, it seems to me, there's an accident, there's negligence, it's minor, and then a person is told by a doctor that they could survive if this is done, and it's absolutely survivable, then it is highly extraordinary for that person not to agree with that.
Well, could I back up? I mean, as I understand it, this was not a woman who was in good health going into this accident. Right? She was already severely chronically disabled. She knew she only had a couple years left of life left, correct? Her emphysema was progressive.
Correct.
So we're not talking about a healthy person with many years life expectancy yet to go declining treatment. She had that condition. She had only a few years left to live. This injury made a bad situation worse. The problems with her lungs are then compounded by kidney failure, so she's going to be dealing with kidney failure on top of that. But I assume that being intubated and being on a ventilator are invasive and unpleasant. I mean, it seems to me that this is not. I mean, people could differ. Her family differed as to whether she should do this, but it's not irrational at all for her to say, I'm already going downhill. I'm only going to live for a couple more years. This is miserable. I want to end it now. Get rid of this. That's not extraordinary. That's understandable.
One additional fact was, as I recall, that her family urged her to actually get the tube. Is that so?
That's correct.
If we adopted your position, might we not be opening a Pandora's box of what then might and might not be reasonably foreseeable?
Well, I think that's something that this court or any court sometimes takes cases fact-specific, one by one, and addresses that.
It's not an unreasonable position, Mr. Gallagher. It's simply trying to sort out where the line is as a matter of, essentially, of tort law, which is then incorporated, into the criminal negligent homicide.
Do you have any cases that help you?
There was no case that I found that was directly on point in looking at the
Is the
Commonwealth's
tort concept of foreseeability the one that's applicable here, or is there a different concept because it's a criminal law with higher penalties?
Well, as the law is, I see it, is that the law has said that the tort concept of foreseeability is in place in this case. I'd point almost, it seems to me that, respectfully, that looking at it from the defendant's perspective, that this woman was in horrible health, and she wouldn't have known that, of course, or wouldn't have foreseen that. And it's a question of, like, what horrible, horrible luck is there on the defendant's part for this accident to have these set of circumstances? You know, what are the chances in an accident that somebody's already going to be close to death? And then what are the chances that that person who is told that their injuries are absolutely survivable, and they choose not to go on? Now, if you look at it from the criminal's perspective and what the defendant is looking at, that those remarkable and unique set of circumstances then make her a criminal.
Well, I must say, there's a lot of fortuity in any case involving a homicide.
Particularly a motor vehicle homicide, just exactly where you hit the car and where the victim was sitting and whether she or he was wearing a seatbelt.
How rapidly medical attention arrives. I mean, there are cases, you know, where a first-degree murder was obviously something much less because of a brilliant neurosurgeon. Happened to save a patient that everybody thought was totally unsavable. Lots of fortuitous things happen that make the consequences of a particular defendant's conduct go to various extremes. So the mere fact that there's some fortuity involved in homicide cases, there always is, in my view, or almost always is,
but with respect,
doesn't change it.
With respect to homicides that are intentional or knowing, in that case,
a manslaughter is a form of homicide.
Well,
you know,
but there's different intents, and when there's an intent to do a wicked or vicious or evil act, then the fortuity should not play a big role. Because
I mean, assault with intent to murder has a maximum of 20 years. First-degree murder has, life imprisonment without parole. There's huge differences in the level of criminal culpability.
I'm saying that the more culpability that the person has, it doesn't matter about fortuity. They should be responsible. They shouldn't get the benefit of the doubt on fortuitous circumstances. But if a person has no culpability, that it's an unintended act, they should get some of the benefit of the doubt.
We're not dealing with no culpability. You would acknowledge at least. In fact, if there had been no car coming the other way and your client had simply run the red light, there'd be a citation, potentially, if the policeman had observed it. There's fortuity that a car happened to be coming the other way at the time. Well, now that we can have causing an accident. And the further fortuity that someone in that car died, well, now we have something higher. There's
culpability
involved.
It's certainly, there's culpability, but certainly at a much lower level of culpability. Another way to look at foreseeability they talk about in some of these cases, just the broad concept of a pragmatic judgment, in a pragmatic judgment where the circumstances, foreseeability won't lie, that you have to look at. Is it such an extraordinary set of circumstances that, practically speaking, this is a situation where a person shouldn't be labeled as a criminal?
Well, I mean, one way is to go back to some of the older jurisprudence, because that's where the concepts derive from. And it seemed to me that in the earlier jurisprudence of this court, which is distinguished between suicide on the one hand and declination of medical treatment may help us. The case that gave rise to that was a motor vehicle accident, which didn't cause the death of anybody, but which caused somebody to become mentally affected, who then subsequently committed suicide. No question that the person subsequently committed suicide, and then the court was trying to decide whether, it's some sort of remote consequence. But that seems to me, there's no question here as to what the triggering event was with respect to medical treatment. I mean, it's not as if she walked out of the hospital, but to go back to Justice Osman's characterization, but it had somehow been exacerbated. I mean, she was fine, she left the hospital, but in fact the emphysema was worse, and she had to, struggle that much more, and so she then decided to end her life. That's not what we have here. What we have is active medical involvement, and she says, look, I don't want this kind of active medical involvement anymore.
But on the intervening aspect of it, it's normally said if the person assumes responsibility of the situation, which this person did, assume responsibility of the situation, then she's responsible for the consequences. She assumed responsibility for the situation when she told the doctor, take the pipe out. And therefore, she's responsible for the consequences and not Ms. Carlson. And I'm sure that the law is clear on that.
Thank you.
Thank you, Mr. Gallagher. Ms. Lazar-Moore?
Good morning. Ellen Lazar-Moore for the Commonwealth. This court has repeatedly stated, excuse me, and reaffirmed as recently as this past March in the case Commonwealth versus Angelo Tedesca Corporation, that generally issues of causation should be left to the jury to decide. What the defendant sought from the trial judge and what he is seeking here is a declaration that as a matter of law, a jury could not have found that the defendant caused the victim's death. But the evidence here showed that the defendant's negligent conduct led to the accident that caused the victim's injuries. And although the victim chose not to remain on a breathing tube, she was put in a position to make that choice by the defendant's negligent acts. Although the victim did have pre-existing lung disease, she had no need for a breathing tube prior to the accident with the defendant.
Can I ask you a couple of fact questions on that?
Yes.
She was first put on the breathing tube for a brief period of time till her breathing stabilized.
Yes.
Taken off the breathing tube.
Yes.
Was it then that there was a kidney failure which really was the precipitating cause for her being put on the tube the second time?
It's unclear. I would say that I'm not sure if this kidney failure actually precipitated it, but it definitely exacerbated it. I'm not sure of the order. At one point, they found that she had blood in the sternum. They did a certain type of an X-ray with dye. She had an adverse reaction to the dye, and her kidney cells started to die, and she started.
So that was clearly a result of the adverse effect to the dye that the hospital used in the test.
Right. And one of the doctors did testify that also added to the problem with the breathing because there would have been more fluid in the lungs that the kidneys were then not flushing out of the body.
Can I ask you another question? It was not entirely clear for me precisely what the jury questions were when they came back. How many times did they come back with questions?
They came back twice. In both questions, they essentially were asking for redefinition of issues of causation.
And the judge basically read his instruction to them twice.
Exactly. In all three of the times when the judge instructed them, in the initial charge and then in response to both questions, he read from the district court model jury instruction.
The first part, but the whole thing, the part about intervening causes, was that from the model district court
Yes,
instruction?
all three times it was the model instruction, except for literally one word, the very last word of the instruction in all three cases. Well, I should first say that the judge initially the judge instructed the jury that the defendant could only be convicted if she set in motion the chain of events that produced the death in a natural and continuous sequence, and that if another event also contributed to the death, the defendant had to be acquitted if the other event was the direct and substantial cause of the death, and the defendant's actions were only a minor or remote link in the chain of events leading to the death. He then instructed them, in addition, that the defendant must be acquitted if the death would not have occurred without an intervening event, and a reasonable person in the same circumstances would not have foreseen the likely possibility of such a result. That is the wording of the model instruction, and that's what he gave the first time. In response to the first question, he gave the exact same set of instructions except the final word. He said a reasonable person would not have foreseen the likely possibility of such an event, And then in response to the second question, he again gave all the same instruction, except again changed the final word to a reasonable person would not have foreseen the likely possibility of such a death.
The whole thing comes down to if a reasonable defendant would have foreseen that they would be in an automobile accident that would cause whoever they hit in the automobile accident, if it was a person in bad health to begin with, which I think is entirely foreseeable, if you think you might have an accident, you could hit somebody that's in their 80s or whatever, if they're in bad health, that they might then, either they or their family might then decide to terminate their life. And
Yes.
I don't see what's not so foreseeable about that.
No, Your Honor, and of course it's the
And you
Commonwealth's
could debate it all
position.
day, but that's the bottom line on this case.
Yes, and that...
Is the result the same if a doctor had committed malpractice in the treatment of this woman and she died?
Yes, except one of the examples that the judge gave in his instruction about the fact that the defendant need not be the only cause of death. As long as the chain of events was set in motion by the defendant and the defendant remained a direct and substantial cause of the death, that she would still be liable even if another event contributed to the death, like negligent medical care.
That is, well, anyway.
And there's no question here that the defendant's act set in motion the chain of events leading to the victim's need for a breathing tube. And the causal chain was not broken by her decision to be extubated because that was reasonably foreseeable. It was so foreseeable, in fact, that there was evidence that the hospital treating the victim actually maintained a pre-printed form where a patient could choose, do not intubate, do not resuscitate.
Oh, they all have
or
that.
comfort measures only. But that's a compelling piece of evidence for the jury that this is the type of invasive procedure that someone might choose not to have. And they did hear evidence about how invasive it is. They heard that in intubation, a tube 1/2 to 3/4 of an inch in diameter is placed 6 to 8 inches down the throat to force oxygen and pressure into the lungs. That if someone remains on the tube for a period of time, it can erode the larynx so that they then have to have a tracheostomy or a hole directly through the trachea, and that the breathing tube is then placed through that hole. There was also evidence that for someone like the victim, it may be more difficult to wean her off of the breathing tube and that she may remain on it forever. And even prior to the accident, the victim had expressed to her family and to her healthcare proxy that she never wanted to be kept alive by a breathing machine.
Well, where is the line on all of this, though? I mean, this case seems to be a little bit, perhaps, on the more serious side. But are you suggesting that whenever a victim chooses not to accept routine medical treatment for a routine, non-serious injury, but that leads to their death, I mean, routine in the sense that it could be easily and readily treated, that converts a fender bender into a motor vehicle homicide?
I'm suggesting that it's a question for the jury, whether it's reasonably foreseeable.
Well, we
and
do
that
have,
a jury
as
would
you-
generally not
But you're saying it's
find
always
that-
reasonably foreseeable that someone will decline medical treatment.
I'm not saying
So-
that. I'm saying that in this case, on this evidence, it was reasonably foreseeable.
For the
That
driver.
this is a very invasive procedure, that the hospital anticipated that people will want to decline intubation. if they even have
But
a
the focus here, I mean,
pre-printed
Justice Sussman raised this earlier, is the focus on the victim's particular circumstance as to whether she or he was making a reasonable decision based on their own medical situation, or is the focus on the reasonable foreseeability of the commuter who has a fender bender with someone in heavy traffic, whether that was reasonably foreseeable for them that this person would have a medical condition, would decide not to accept routine treatment that would have saved their life, and converted a fender bender into a homicide?
Right. I would say that the focus is on whether a reasonable person in all of these circumstances.
The defendant's circumstances.
Right.
No,
The
no,
circumstances
that's
per-
not the case.
No,
It is
the
whether or
circumstances
not it's
pertaining to the
reasonably
incident.
foreseeable, it's reasonably foreseeable that somebody will decline medical treatment. As Justice Sussman says, there are some people who decline medical treatment for reasons which the overwhelming majority of people would say is patently unreasonable.
Yes,
And
Your Honor.
most particularly, those are in religious cases. But the question is is it reasonably foreseeable that somebody will decline medical treatment?
Yes, I thought that that was what I said. The focus is not on the reasonableness of the medical decision, because certainly people decline treatment for all different sorts of reasons that we might not agree with. Although I will say, just as a factual matter, that the evidence was not viewed in the light most favorable to the Commonwealth, was not that the doctors told the victim that she would definitely die if she went off the tube. Her daughter-in-law testified that the doctor said, well, we don't know what will happen. It would probably help your chances to stay on it. But in any event, no, the focus is not on the reasonableness of the medical choice. It is on the reasonable foreseeability of whatever the intervening event is.
And it's always reasonable, and but your position is it's always reasonably foreseeable that someone will decline even the most routine medical treatment. It's just reasonably foreseeable.
No, that is not my position. My position is that it was reasonably foreseeable, that the evidence here showed that it was reasonably foreseeable that someone would decline this particular medical treatment, that there was evidence of that this is extremely invasive, that it's difficult to live on a breathing tube, that it's painful, that it can erode the larynx, that you may need a hole in your throat, that the hospital maintained a pre-printed form for somebody to decline this particular medical treatment because it is so invasive.
But of course, the driver would not be able to reasonably foresee any of those facts. Can I reasonably foresee that the person...
To foresee the specifics. I mean, this is
right.
what we seem to be getting bogged down in.
Yeah. Isn't your position really that what resulted was a logical process given the victim and the accident, and it was reasonably foreseeable, but every specific of it doesn't have to be reasonably foreseen?
No, it doesn't have to be reasonably foreseen, but just reasonably foreseeable.
But that's my point.
But that's what
saying,
you're suggesting that it does, though. You're taking your argument too far. You don't need to go that far in order for your side to win.
No, I am just saying that in this particular case, it was reasonably foreseeable based upon all those facts. I'm not saying that you need to have all that.
If the victim in this case had been intent on committing suicide, would that change the result?
I think that it would depend. It would depend on exactly how they committed suicide, how remote it was from the accident.
They intended to commit suicide by not taking advantage of offered medical treatment.
Again, depending upon what the treatment was and whether it would have been reasonably foreseeable that somebody would decline that type of treatment. I don't think it matters in that case what the state of mind is of the person who declined the treatment.
Again, it seems to me we have to take into effect that there are some people who decline all medical treatment for religious grounds. So Justice Gowns says, I'm not quite sure that we have to parse this as finely as you are saying. I'm not sure what's wrong with a thing that since it is foreseeable it's always foreseeable that somebody might decline medical treatment, then it's foreseeable without regard to the specifics of what the treatment is and what causes this person to decline that treatment. I'm not sure we need to get into that at all, frankly.
Do you agree with that?
That it will always be reasonably foreseeable?
Well, because doesn't it follow then that in every automobile accident that it's foreseeable that perhaps the person who's the victim will decline medical treatment?
Yes, Your Honor, I don't necessarily agree that it will always be reasonably foreseeable. If it is something that is so minor, let's say that the person didn't take an aspirin, I don't think that it will always necessarily be reasonably foreseeable. I think that what the issue comes down to is here, more important than anything, is that this was an issue for the jury. What the defendant is asking for...
You're not helping the court at the moment, because that goes to this case. There are some cases which are so at the outer limits which we recognized in Tedesco. And you are so well within it that if I were you, I wouldn't keep trying to find what the outer boundaries are, because you are well within it.
All right,
Right?
then I apologize.
No,
I'm
no,
not
it's
trying
just
to
that-
be unhelpful. I'm just trying to answer questions that pertain to my case.
Well, I think the instruction was entirely correct, and on these facts, the jury certainly could find that this defendant sent into motion a chain of events that resulted in the death.
So do I, Your Honor.
And do we need to keep debating it?
I don't think so, and
The question is, it's your case and there are particular facts, but there's a rule of law that has to apply to other facts, and the fundamental claim that the defendant has made is that if you decline medical treatment, right, if you decline medical treatment, that's an intervening cause. And although we can go at great detail into the particulars of this case, there are lots of other negligent homicide cases out there, quite a lot of negligent homicide cases out there. And as medicine becomes more and more and more and more sophisticated, so the capacity of medical interveners to intervene is a reality with which we have to deal. I doubt whether in 1903, when we decided the whatever the case was, the Daniels case, that intubation was even possible, right? So you have to, all I'm trying to do is to say we have to set the rule, and is there any reason why we can't say, you know, it is foreseeable that people will decline medical treatment, especially invasive medical treatment?
certainly there's no reason that you cannot say that, and if you were to say that, then
That's the end of the
course,
case.
my case falls well within that.
Yeah.
Thank you, Mr. Zalmore.
Thank you.